Ladies and gentlemen, welcome to the HR Cartel podcast. I'm your host, Tim Dive. If it's your first time, welcome here. Come back again. Do me one favor. Hit like, follow, subscribe on whatever platform it is you're listening or watching this on, because that's how we reach more people, right? We're here for small and medium-sized employers, and that's companies with anywhere from 0 to 200 staff. We're their voice. That's who we are. And do me a favor, if you know someone that runs a business, share this with them, because I guarantee they're going to get a whole bunch of value out of it. And let's connect. Go to our socials. Look for the HR Cartel everywhere, and let's connect. Right. Let's just talk about some ridiculousness, shall we? There's a bit of stuff going on at the moment. This Coles versus Woolworths. Sorry, not Coles versus Woolworths. Coles and Woolworths. There's a case against both entities, and the bill at the end of the day for these companies is $1 billion in underpayments, right? And that's not a big shock, and I'm sure many people out there will be going, "Who cares? Who cares? It's Coles and Woolworths. Don't worry about them." I understand, I get it, but for all those smaller companies out there that employ people and pay annual salaries, and there's a whole lot of you, millions, I would say, massive danger, huge risk. So we've got to talk about that. If you haven't paid attention to it, if you haven't heard about it, many law firms have been digesting the decision and giving their legal views and opinions on it. And it's just very technical. So we're going to avoid all that. I'm going to give you the few takeaways that I've landed at, with some legal education and input. But where I've landed, I'm going to share that with you, so you can operationalize what you've got to do to protect yourself, because the penalties are huge for this stuff, right? You don't want to get caught out. And just some other stuff, some ridiculousness. Let's start with AI, shall we? AI is one of those things that just isn't that smart yet. I know, you know what? I don't care if you're going to beat your chest at me and say, I don't know what I'm talking about. AI is changing the world and it's the smartest thing and we're going to be obsolete. I don't believe it. I just don't believe it, right? And especially I don't believe it today. I don't know what it's going to be in 10 years. I don't. But let me tell you, AI is not that intelligent. It's not. And we use it, don't get me wrong, right? We use AI a fair bit. I just don't see the doom and gloom and how it's going to destroy everything and take us over and do things better than us. I cannot understand how people are landing at that point. And I use AI every day, right? No, I'm not an expert. I'm not. But let's look at AI and Deloitte, right? I'm sure you've seen that. It's been in the news. The government's paid almost $500,000 to get a report done from Deloitte. Now, don't get me started on the big four either, right? Deloitte, KPMG, Ernst & Young. Who's the other one? Don't even know, right? But the big four consulting companies. PwC, that's the other one. And we all know that the schmozzle they had with a leak of government information that pretty much destroyed their reputation. Somehow they're still alive. I don't know. Look, they're all the same. Ernst & Young, KPMG, PwC, all these big four, they're all the same. They're the same as massive law firms too. They get younger, more ambitious people in there. They burn them out. They put the nose to the grindstone, burn them out, churn them out. Those who don't survive, good riddance. Those who do eventually stick around and hope to become partners, right? That's the model. It hasn't changed, and it's so unfortunate that a couple of years ago that woman in Sydney, I think it was, took her own life while she was at work working for one of these businesses. And that's about where the serious focus on psychosocial hazards at work came from, that really spurred all that movement on. These big four consulting firms, they're bad businesses, they're bad cultures, they're not good places to work, right? Prove me wrong if you disagree. Anyway, they've taken $500,000 almost off the Australian government and produced this report, and they've used AI to produce it. The media will say that they've used AI to produce certain sections of it. I guarantee you the whole bloody thing has been created by AI, with them inputting some pre-existing information into the AI large language model and giving it some prompts on how to use the information they gave it to produce reports, right? The ChatGPT and the Microsoft AI, I think they used, and they got caught out. They got caught out because the work was bullshit. It was rubbish, right? It's it had references in the footnotes that were false references, that were fake. There was made up court quotes that were never said. All kinds of things, right? I'm not going to go into detail of exactly what was wrong about it, but the point is this. The point is this: be very careful what advice you're listening, and check everything, right? Regardless of what kind of reputation or size of company or whatever that you're dealing with, don't be lured into a false sense of security, right? These big businesses are not using 25, 30-year experts to produce a report for you. They're not doing it, right? You know, sure, they've got their place. You know, I've used KPMG in the past when I've been working with businesses to do forensic accounting and some specialist stuff like that, of course, right? They have their place. Listen, these reports and stuff that they're producing, they're getting kicked down the ladder to the entry level associates and graduates and those sort of people, and they're producing that stuff. That's who's doing it. Of course, they're going to use AI. Of course they are. They've got no life experience. They've got no work experience. They've got no baseline to judge things on, to make assessments of things on. And obviously what's happened here is that the higher ups haven't checked anything, right? They just haven't checked it. They don't care, right? All these big businesses are concerned about, the consulting companies are concerned about is revenue, right? Because partners get a lot of money, provided they churn revenue into the business. So they're not even giving a refund. They're giving a partial refund to the government. So how's that? Now, look, all about this is not an AI podcast. It's a HR podcast. The HR Cartel does use AI. I'm going to make a statement here for you right now, and an assurance for all of our members and potential members, anyone who wants to become a member and work with us. I'm going to tell you exactly right now, we've got an AI policy, and I'm happy to share it. I can even maybe get a link together for the show notes to share our AI policy. Or maybe I'll put it on our website. Maybe that's a good idea. And, you know, I've given my team firm rules around how we're going to use AI. AI is not to be trusted for advice, for decisions, for determinations, right? What AI is to be used for in the HR Cartel is to fast track research. You know, we'll create our own GPTs. We'll educate those GPTs, and we'll put a whole ton of information into it, court decisions, award variations, all sorts of things, right? We will use it, and we're going to use it to fast track our research, you know, to run ideas by, to point us in directions of where we should be looking with our own two eyes and reading with our own two eyes, making our own decision with our own minds. And it's a rule in this business, not a single piece of advice, written or verbal, is issued to any member, any client, anybody that's from a large language model. Not a single word will be uttered. It's the consultant. It's the person who knows the business, who's working in the grey, right? That's who gives the advice. That's who makes the decision. That's who makes the determination. AI is nothing more than a tool, and it should never be seen as anything more than a tool. So, you know, we are not an operation like these big four consulting companies who are producing client documents straight out of AI. Ridiculous, right? Ridiculous. So, look, I'm sure I ruffled a few feathers here. I'm sure some of you out there are disagreeing completely with me about my take on AI and its importance and that sort of thing. Challenge me. Tell me, give me some other examples as to why I'm wrong about that. I know the grandfather and the godfathers of AI are all about doom and gloom and saying it's going to destroy the world and all this sort of stuff. You know, whatever. It's just another evolution. It's an evolution. You know, so who cares? That's Deloitte. That's Deloitte for you. Some other ridiculousness going on. Let's talk about this case. I've mentioned this case before, but I've never really gone deep on it. I won't go that deep on it now too, because I'll just sort of skirt around all the relevant elements to give you the idea of the ridiculousness of it and how bad our system has become. Before I jump into that, let me just say this, a little side rant. I'm now firmly of the belief there isn't a single company, business in Australia that employs people, even if those employees are overseas, and none here in Australia, even including companies like that. I'm firmly of the view there isn't a single employing entity in the country that doesn't break the law every pay cycle. The workplace regulations, the Fair Work Acts, state-based acts, all sorts of things, right? We've now got that many laws that we have to comply with. It's impossible to run a company without breaking the law. Now, here's the question. How many of those laws qualify as criminal? Wage theft, for example, right? Are Australian companies criminal organisations just by way of their standard operating practices? They're certainly breaching laws that will put you in front of a court for civil penalties, 100%, without a doubt, every single pay cycle, every week, fortnight, month, whatever it is. Not a doubt in my mind. So here's something I'll put to you as well, right? Right now, we're in a country that is so far left-leaning, so far socialist, so far union-controlled in terms of workplaces, industrial relations, that unions have that much power. How far off are we from a union or a head of a union, someone being able to influence the Fair Work Ombudsman who is also ex-union, right? ACTU, also an ex-commissioner. How far off are we from having a union head influence that ombudsman to send one inspector to a company that won't play nice with unions any day of the week, just to go, hey, show me your payroll records, with a 100% guaranteed rate of failure, and them knowing that, right? How far off that are we? I think we're pretty close. I think that would happen today. Now, I'm not saying with that statement, I'm not suggesting that all these people are in a room together, that Anthony Albanese and Amanda Rishworth, the IR minister, and Anna Booth, the ombudsman, and all the union heads, and they've got a list of companies and they're conniving together going, they're first, they're second, they're third. I'm not saying that's what they're doing, right? But they have got so much momentum now, so much momentum. We'll talk about some of this ridiculousness in this podcast. They've got so much momentum that this is where we're going to end up. It's going to happen. It's not a question of can it happen, will it happen? It's who is it going to happen to, and how far off that are we? There's so many laws in this country now that we must comply with. It's impossible to run a company without breaking at least a few of those regulations and laws, potentially criminal, every single pay cycle, perhaps even per employee, right? So I'll park that. I'll leave that one with you to ponder. Let me get back to the point I was going to make. This ridiculousness about this, the worker, an Indian worker who was employed, Australian company, it might have been an Australian company, at least a global company, based over in India, right? Infosys, I think was the company, based over in India for 6 years or something like that. Came to work in Victoria for 3 years, right? Put in a request while in Victoria to get long service leave. Was rejected by the Victorian state government. What a surprise that is too. Hey, let's talk about that. Does Victoria's state legislation that governs long service leave make more sense than Queensland? I think it does. Well, yeah, what about that? So anyway, puts in a request in Victoria for long service leave. It gets rejected because there are certain terms and conditions in Victoria that say the work that's been performed for an X amount period of time that you have to work for continuously to get the long service leave has to be connected to Victoria, right? So because of that, declined, didn't work. Went to Queensland, relocated to Queensland, still employed with his business, put an application, and while in Queensland, then qualified in terms of tenure including that 6-year period in India and the 3-year period in Victoria, ticked over the eligibility timeline for Queensland's long service leave. And I think they'd only been working there for about 11 days or something like that. Right, and they ticked over. Put the application in, bang, approved. How's that? How is that? Ridiculousness? Yes, ridiculousness. It's so in Queensland, it's a 10-year period that you got to work for long service leave, right? You qualify at 7 or 8. I can't remember now. I think it's 7. It becomes guaranteed entitlement at 10. If you resign or you move on for misconduct or something like that between 7 and 10, you don't get it. If you're terminated because of redundancy or something like that at the employer's initiative, not for any fault of your own, you'll get a prorated amount between the 7 and 10-year period. But if you hit 10, regardless of your exit reason, termination, redundancy, regardless of all that, you're guaranteed the long service leave payment. Now, this person only worked in Queensland for 11 days and got long service leave. So how is that, it's just these rules. There's so many layers and levels of rules that govern our workplaces that we don't understand, that we misinterpret all the time, that we get wrong until something stupid like this pops up. This person does not deserve Queensland-based, long service leave, right? Obviously, they don't. But they got it. They're entitled to it under the law. So how's that? That's one there. Look, moving on to something else with a bit of ridiculousness, and I might. This is a big one actually because there's so much you can talk about here. And in fact, we did a webinar on this very topic, and we only got halfway through in an hour and 10 minutes. We only got halfway through the things that we wanted to talk about. So we're doing a part 2 webinar. That part 2 webinar, let me plug that one. It's going to be in about 2 weeks' time from today. So probably a couple of Fridays from today, we'll do part 2 of that webinar. So keep your eyes peeled on our socials, and if you're a member, on the portal and in your inbox for an invitation to that. But we're talking about the Coles and Woollies stuff and the annualised salaries, the determination in the federal court that says you can't offset with annualised salaries any more than one pay cycle and all that sort of stuff. Look, it's ridiculous. It's ridiculousness because of one thing. The ridiculousness there is that for so many years, we all assumed that paying an annual salary meant that across the year you were better off. That's what everyone assumed, okay? There's no question about it. Some people will tell you, no, I told you so, or I didn't think that. Well, good on you. Why weren't you saying that years ago, right? Because everyone was saying that, it's not just for one pay cycle. An annualised salary goes across the year. Now, if you look at an annualised wage arrangement in a modern award, I'll give you an example, the Clerks Private Sector Award, it says you can do one annual reconciliation to make sure you're paid enough across the annual period. That's what it says to do, right? But here's the thing. It all comes down to when entitlements are owed. I'm not going to go through the case law, the decision, that sort of stuff, and bore the hell out of you, but I'll give you a bit of an easy way to understand it. In this webinar, what I said was this: an annual salary. Now, this is a result of the decision of the Coles and Woolworths matter, right? What I'm pulling out from it and how I'm explaining the outcome to our members and clients is this: setting up an annualized salary or an annualized wage is not offsetting. Not offsetting entitlements. It's not offsetting loadings and penalties and overtime and that sort of stuff, right? All it is doing is demonstrating that you have an intention to do that over the year. Over the year this person's employed, your intention is to pay an annual salary, and your intention is to have that annual salary offset some things. In order for something to be offset, though, it has to be owed. And in terms of a workplace, an employee is only owed something if they've worked. And these entitlements are assessed by pay cycles, pay periods, right? 1 week or 2 weeks or a month, whatever it is you do. So as such, you can only offset an entitlement if it's owed. So the offsetting is only allowed to be in full one pay cycle at a time. As such, you cannot use imaginary or future intentions or imaginary offsets to not pay something. That's the simplest way I can whittle it all down. This massive decision in these two cases, or the Coles and Woolworths matter. That's the easiest way I can whittle it all down, right? An annualized salary is nothing more than an intention to offset. You're telling someone you intend to pay them this much money, and that will also set the expectation that they're going to be required to do work potentially up to that level, right, across that year. But it's nothing more than an intention. It's not offsetting anything. Offsetting clauses, however, must be drafted properly, right? So offsetting is when you've paid above an award entitlement, and you've paid above what a person is to be paid per hour, the award's hourly rates, right? With the intention that overpayment acts as a buffer. And so when overtime and penalties and loadings are applied to a person's rate, that buffer, that extra you've paid, has squashed it down and covered it all. Right. So your offsetting clauses in your contracts have to stipulate specifically what it is you're offsetting. And we know this because Commissioner Hunt in the Fair Work Commission made a ruling about 2 months ago or so, whenever that was, that a person took their employer to the tribunal, and even though they're receiving an inflated hourly rates, Commissioner Hunt's position was, well, your contract doesn't tell me that you intend to specifically to offset overtime, so you can't offset it, right? So, we've got to get clear on these things, right? Annualized salary does not mean that you're offsetting. It means you intend to. Your offsetting clause must specifically say what you intend to offset. And that's loadings, overtime, penalties, things like that. So, we've got clarity now, right? Ridiculousness, I don't know if I'll put it in that box, but at least we've got clarity now with those cases. I was really hoping with all of me that that Coles and Woolworths thing would be disputed and sent to the High Court to have a High Court decision on it. But with a closer inspection, a closer look, the sections of the Act, even in these modern awards, in the annual wage arrangements, that there is wording in there that talks about pay cycles as well. So, we were all assuming wrong. We were all assuming wrong, much like with the redundancy and redeployment situation from a couple of months back as well. Where if a person's redundant and you've got contractors filling positions and casuals filling positions, those positions are up for grabs with redeployment. Someone's sitting in that job's being performed, it's outsourced or whatever. You have to take that job off that person and redeploy a person into their job. Now, we've never operated like that, but much the same as this scenario, we've now got the determinations from the court that say that's what you have to do, right? So some more ridiculousness there as well. And there's more coming, right? There's more coming. I think I'll give you an update on the non-compete clause situation just to close this one out, because frankly, I think that's more ridiculous than anything. But the government is going ahead with the non-compete clause. Actually, there's one more thing we'll finish off on top of this as well, which is the right to work from home stuff, which has been set for a court hearing for a tribunal date next year. Non-compete clauses. Next year, they're coming into play, I think next year or very early 2027. So we've got about 12 months, right? Maybe a bit more. But the intention, we haven't seen legislation yet. We haven't seen a bill yet, nothing like that. But we have received indications that the intention is what we feared, It's not just about stopping people from going to other companies that compete with you or setting up a competing company. It's not just about that. They are removing the ability that companies have to stop employees taking client lists, for example, and starting their own company and calling your clients one by one to get them to come and work for them, or going to your competitor with your entire client list and calling them one by one saying, "Hey, I work here now, come to me," right? They're also including the restrictions on these clauses. They're also making sure that you can't stop your employees from tapping the ones who have exited, from tapping all the ones who have stayed on the shoulder and say, "Hey, leave these guys, come with me." They're stopping that from being lawful to try and block as well, right? Um, Again, all things that we're very fearful of for small employers out there. So that has been confirmed to coming. So we were worried about that being the extent, or expanding that far out to have that much reach, and they confirmed that that is the intention. So worried about that. What we've done to counter that, we've been drafting our own new clauses in contracts that take the focus away from looking at post termination control to during employment control. Breaches of confidentiality, we've listed all kinds of things that will qualify for that. We've made sure it's clear in contracts. They understand this is gross misconduct. And what it's going to take, really moving forward, is that employers are going to have to start doing proactive audits. Get your IT people to go into people's accounts, see the activity that they've been doing with their technology, with your laptops, with their email addresses. Have they been plugging USB sticks into the computer and doing mass data transfers? Have they been downloading or creating exports of client lists, emailing it to themselves, or emailing it to email addresses that aren't stakeholders of your business? Or maybe it's their personal email address. Maybe it's their partner's personal email address. It's going to take a lot more effort during employment, while employed, to watch what people are doing, to identify the signs of when they might be trying to do the wrong thing by you, right? That's the angle we're going with it. So if you're a member of ours, your contracts are starting to pepper this stuff into your contracts now. Not so we're scrambling in a year from now trying to get it all happening now. So if you're a HR Cartel member, that's what we're doing, right? So the last thing here really is just working from home, right? The president of the Fair Work Commission, Justice Adam Hatcher, they've set a date next year, I think early next year, to have this heard in a hearing scenario. So expect that to come soon too, right? And what the deal here is, they're drafting into the Clerks Award. Now, this is strategic, and there's a reason for this, right? That Clerks Award covers probably a couple of million employees in Australia. It's a massive, wide-reaching award that isn't industry restricted, and it reaches every sector, almost every sector, right? They're writing into that award a right to work from home, not a right to flexible arrangements, not a flexibility arrangement request rights. That already exists. A right to do their job from home. And that's alarming, it's absolutely alarming, because the intention is to take it from that award, then roll it out to others. So keep an eye on that. We'll put some submissions if we can, and share your thoughts with us if you want us to put some submissions in that share your thoughts. If you're a HR Cartel member as well, you certainly will. But you've got to wonder why they would even do this when flexibility requests already exist. And one thing for me is this: the flexibility request criteria is you've got to be there for 12 months. You've got to have a sick child or parent, or immediate family member. You've got to be pregnant, or you've got to have a school age child that you're caring for. There's all this criteria, right? So I think they're trying to get around having all this criteria and just instantly, like this, giving any employee the right to tell you how they're going to perform their job. Now, the employer groups have rallied and they've asked, well, if that's the case, then we need to be able to say, well, if you're determining when you're going to do the hours, who's to say that the hours you choose you're going to do within the award are outside of the ordinary hours scope, and now we're going to pay you penalties just because you've got a right to work from home, and I can't control that, right? Now, strategically, remember what the government did not too long ago? They stopped and blocked the Fair Work Commission from making any decisions that interfere with penalty rates being payable. Do you remember that? It was just a couple of months ago, right? They put a new law in. They interfered with the commission. They blocked their ability, and the commission had this right. The commission had the ability and the right, the lawful obligations to hear matters from employer groups, unions, and employees about penalty rate issues, penalty rate matters and awards. The government said, no, we're going to change that law. You can't make any change to any penalty rates in the sense that penalty rates become non-payable. So good luck, employer groups. Good luck, employers. And I'm one of them. I hate it. I can't stand this work from home matter. It is an absolute sham, and it's a middle finger to the face of all small business owners in Australia. That is ridiculous. So we'll end on that, right? The podcast of ridiculousness, we'll call this one. Go to www.hrcartel.com. Check out that website. If you want to be a HR Cartel member, reach out, go to join the cartel on that website, and scroll down a little bit. There's a form there you can fill in. Tell us who you are, what sort of company you are, and get in touch with us. On that website, you can download our 2025 Industrial Relations Forecast if that's of interest to you. There's a whole range of value on there, right? Go on there and check it out. If you're a member and you've got some concerns about any of the things that we raised in this discussion, I know we're having a bit of a tongue-in-cheek conversation about it, but underneath all that, these are really serious matters that cost us a lot of money, a ton of money, right? They put a lot of pressure on businesses, and they seem ridiculous in the moment, and the way you respond to what you think seems ridiculous could end up costing you a lot of money in penalties and claims and all sorts of things. If you've got any concerns, if you remember, reach out to the advice team. You know how to do it. You know where we are. Until next time, keep a tight workplace, and we'll talk soon.